Hello students and welcome to the lecture. So students, as you could see that basically in this lecture we are going to start the lecture on the center-state relations. Alright, so we are going to see the center-state relations, how they operate with each other and how they coexisted with each other. Alright, and basically these are the topics which we have scheduled for the discussion, like the introduction part. Thereafter we will see the legislative relations, then the administrative relations, like the financial relations, like the trends in the center state relations. Okay, so these are the topics which we are going to see in this particular series of center and state relations. All right, so I hope that you will be ready for it. So let's begin. So first is the introduction. The Constitution of India and the Governing Book of India, being federal in structure, divides all powers, which is the mainly division of legislative powers, executive powers, and the financial powers between the center and the state. So basically, as I have told you many times, that whenever we talk about India, then remember in India there is a federal structure. Okay, which means that in India we have two levels of the government: the central government, all right, and the state government. Okay, as we know, the central government is basically operates at the national level. Okay, and govern union territories directly. Okay, except two union territories, which are the Union Territory of Delhi and Puducherry. All right, except these two union territories, basically the central government controls and governs all the other union territories and all the matters of the national level. Whereas whenever we talk about the state government, then the state government is not too vast. Basically, they governing respective state. It means that basically, if we're talking about the state government of Telangana, for example, then basically the government is responsible to govern the Telangana state. Similarly, for Kerala, for Uttar Pradesh, Rajasthan, Goa, whatsoever you could call it. All right, this is the thing, federal structure, and basically there is a division of power. Like whenever we talk about the government, then government having three types of divisions in power: the legislative powers, all right, the executive powers, and thereafter the administration. Or sorry, financial, not administration, but the financial powers. Okay, remember that here we are talking about the powers, not the division. Okay, because whenever we talk about the organs or the divisions of the government, then these are three types of things, like the legislative organ, all right, thereafter the executive organ, and the judicial and the justice organ. Let's write it as a judicial. All right, legislative organ, executive organ, and a judicial organ. Okay, all right. So remember that these are the government organs. All right, and this is the government powers. All right, I hope now you have got the difference between this. All right, so that is the federal structure of the Indian country. Okay, however, there is no division of judicial power, as the constitution has established an integrated judicial system to enforce both the central laws as well as the state laws. So what we are seeing here, like as we know that the government powers are basically divided between the central government and the state government. Okay, at the central level or at the state level. But when we talk about the government organs, then they are not divided. government organs are not divided, only the legislative powers and the executives are divided, but judicial powers are not. It means that you could not say that there are the two types of court. One court is basically implemented the federal laws, and the second court is implemented the particular state law. No, nothing like this. Basically, in India, we have the integrated court system, like the Supreme Court at the top, thereafter the states high courts, and thereafter the district courts and the subordinate courts. All right. So basically, all of these are integrated with each other. Okay. So you could say that out of three government organs, two are divided between the center and the state, but the judicial organ is not divided. It is integrated and common for all. Why? Because there is common constitution for central level as well as state level. There is common constitution for central level as well as state level. Okay, that's why there is integrated judicial system to enforce both the central laws as well as the state laws. Got it? So the center and the states are supreme in their respective fields. The maximum harmony and coordination between them is essential for the effective operations of the federal system. It means that neither the center nor the state interfere in each other's matter. Alright, it means that central government could exercise their power at the central level, state government could exercise their power at the state level. Okay, so they having the harmony. Why? Because they are not interfering in each other and having the coordination. Why? Because they are governing side by side the same country. Okay, if we're talking about the central government is governing India. If we talk about the state government is governing the part of India. So they both are operating with each other within the same boundary. Okay, so that's why they having the coordination, and this is very very necessary. Until or unless this coordination not existed, the federal structure could not be worked out. Okay, because if the state government is not cooperating and coordinating with the state central government, then what will happen? The central government will acquire the state government, and that will be a finishing off of the federal system. Similarly, if the central government violates the boundaries and start interfering into the state matters, then what will happen? The state governance will be disturbed. Okay, and this could create the chaos. So that's why the central government never interfere in the matters. Hence, the constitution contains elaborated provisions to regulate the various dimensions of the relation between the center and the state. The center relations can be studied under the center state relations can be studied under the three headings, which are the legislative relations, administrative relations, and the financial relations. Legislative relations, how they interact with each other in the legislative terms. Administration, how their administration works out. And financial, like how the financial powers are divided in between them. So basically, in this entire series, whatever we will learn, whatever we will discuss, basically we will discuss around these three powers. All right. So I hope the things are now very much clear to you. All right. So first is the legislative relations. Okay. It is basically the law-making powers. Okay. So there are Article 245 to 255 in the part 11th of the Constitution deals with the legislative relations between the center and the state. Now it is very very important, this thing. Okay. Questions may be directly asked in the examination, like the center state relations, part of legislative relations are mentioned in which articles and in which part. So if you are not revising them on the regular basis, I could guarantee you that you will get confused. Why? Because suppose if this is written down, that whether it's part ninth, okay, part 11th, part 12th, or part 10th. Okay. So if you are not aware about this thing, okay, and if you haven't revised this thing, what will happen? That surely you will get confused in this. Why? Because these are the Roman numbers. And believe me, the Roman numbers having one thing very common, that they all seems equal and they all seem same. Okay. That's why I'm telling you, your revision is required here. Like you are required to do regular revisions until or unless you get the exact number in your mind be fitted. So that once you see the options, your mark should be this. Directly you should mark this. Okay. Similarly, if we talk about the articles, then the articles are from 245 to 255. Okay. So maybe if your luck is good, all right, then the question will be like which article contains this and that, then you could directly mark the question. But suppose if the question is little bit tricky and little bit tilted, and the question asks like how many articles are provided into the constitution which deals with the legislative divisions between the center and the state relations. So now you have just read it out the articles. You are not aware about the numbers. Then what will you do? You will get confused. But if your concept is clear in your mind, then you will simply subtract them and you will get the answer as in that there are 10 articles provided into the constitution that deals with the thing. Okay, there are total how many articles? 10 articles which deals with the legislative relations. Okay, so this is the thing. Beside these, there are some of other articles dealing with the same subject. Like any other federal constitution, the Indian constitution also divides the legislative powers between the center and the states with respect to both the territories and subject of legislation. Okay, it means that if we talk about the other countries' federal structure, in which there are two government existed, like the center and the state government, system is very much similar in both. Central laws are different and the state laws are different. Okay, and this is basically done by defining the territories and the subject of legislation. Okay, like the central territory is all over the India. All the parts of India covers under the central territory. Whereas when we talk about the state territory, then the particular state area. Even the central laws could be implemented in all over the country, in every part of the country. Whereas the state laws could only implemented into the selected state. All right. So that's how the territory and the subject of legislations have been divided. Further, the constitution provides for the parliamentary legislation in the state field under 5 extraordinary situations. Okay, as well as center's control over the state legislation in the certain areas. Okay, so what we have seen, that right now we have just seen that there is a division and separation of powers. Okay, that there is a division and separations of power between the center and the state. Okay, but here is one thing which we are required to find it out, and the thing is that constitution provides for the parliamentary legislation. Parliamentary legislation means the central level. Okay, basically when we talk about the legislation power, then at central level the power is not vested with the central government, but basically vested with the parliament. Whereas when we talk about the state legislation powers, then the powers are not vested with the state government, but vested with the state legislature. Okay. So basically, here the constitution provides, it is powered by the constitution. Okay. That the parliament having their supremacy and having the provisions that the parliament could establish the supremacy over the state legislatures in 5 extraordinary situations, as well as not only the state legislative relations, but even the central could control the state and its legislation in certain cases. All right, it means that basically there are certain powers in which the parliament could exercise the control over the state legislation and over the state power, and you could say that basically parliament could override the provision of state legislation division. Okay, so what are these? First, territorial extent of the central and the state legislation, distribution of legislative subjects, all right, parliamentary legislation in the state field, and the central control over the state legislation. All right, so remember, first is the territorial extent of the center state legislation, distribution of legislative subjects, thereafter the parliament legislation in the field, and the central's control over the state legislation. So these are the certain extraordinary situations. All right. So first is the territorial extent of the central state relations. What does it mean? The constitution defines the territorial limits of the legislative powers which are vested with the center and the states in the following way. Okay, like what are the powers of the center and the state in the matters of territorial extent? Okay, first is the parliament can make laws for whole or any part of the territory of India because it is covers all over India. So if it's cover all over India, it means that it is totally depend upon the parliament, that whether they want to make a law for all over the country or any particular part of the Indian territory. All right. The territory of India includes the states, the union territories, and any other area for the time being, including the territory of India. Okay, it means that the area is to be acquired, or you can say through some referendum or plebiscite, have been attached with India for a while. Okay, so basically, until or unless the area is counting as a territory of India or be the part of the territory of India, the central laws which are making by the parliament could be implemented there. All right. A state legislature, on the other hand, can make laws for the whole or any part of the state. Okay, so they could include the entire state or any part of the state or district or certain areas, but only about the respective state. Okay, for example, let's take example of Arunachal Pradesh. Okay, so if we talk about Arunachal Pradesh, it is a northeastern state. Okay, and it is a home of various tribes. So the state government of the Arunachal Pradesh having the power that whether they could make the laws which will be implemented in all over the state, first thing, or it could be implemented into the certain tribal regions of the state. So that's make the difference between the whole state and any part of the state. Okay, the laws made by the state legislature are not applicable outside the state except when there is a sufficient nexus between the subject and the state. All right, so you could say, suppose, let's take an example. If we're talking about the Karnataka and Tamil Nadu. All right, then Karnataka and Tamil Nadu both are the southern Indian states. Okay, Karnataka is a state for Kannada speaker people. All right, and Tamil Nadu is for the Tamil speaking people. All right, they both are different. Okay, but the laws which are making by the Karnataka and the laws which will be making by the Tamil Nadu, they both the laws will be applicable only in the particular territory of Karnataka and Tamil Nadu, because as we had seen, the territorial extent of the state is only limited to that particular state. It means the Karnataka laws will not applicable into Tamil Nadu. Similarly, Tamil Nadu laws will not be applicable in the Karnataka state. But there is a situation which we called as an exception, that when there is a sufficient nexus between the state and the object. Okay, so why I'm taking this? Let me explain you a scenario so that you could understand it better. This is Karnataka. This is Tamil Nadu. Okay, they both having the river flowing between them. All right, and the river name is Kaveri. And Kaveri is one of the India's most famous rivers. All right, and very beautiful. Okay, so what happened? Like Karnataka and Tamil Nadu, both are sharing the Kaveri. It means that they both are sharing the water resource. Okay, so for a long time, there is a water dispute between them, which is famously known as the Kaveri water disputes. Okay, and the prime reason for this, okay, is that the locals of Tamil Nadu and the locals of Karnataka, they always said that the other side is using the excess amount of water, so that the other side is not getting the sufficient water supplies. And this is a merely a reason, and this is not the only example of water dispute in India. Various states are having the problem with the water dispute. But right now, what I'm trying to say, I'm just trying to explain you the exception here. All right, so do not take it otherwise. Be rational and be attentive in this. All right, so basically, the Kaveri and the Kaveri shares the water in the Karnataka and Tamil Nadu state. So suppose if the Karnataka government makes some law regarding the Kaveri, okay, so this is a sufficient nexus that the laws of Karnataka will affect the people of Tamil Nadu. Similarly, if the Tamil Nadu government had make the laws, all right, then the laws will affect the people of Karnataka on the surely basis. Got it? So that is the this. Why? Because they having the sufficient nexus between state and object. All right. So that was the exception. So we could say that basically the state laws are highly applicable to that state only. All right, they have nothing to do with the another state until or unless there is a sufficient nexus between the state and the object, like I have told you. Karnataka and the Tamil Nadu both having the sufficient access to the object river Kaveri. So if any government makes the law regarding with the Kaveri water, then ultimately the law will be affected the other state people. All right, because they both are sharing the common thing. All right, thereafter there is a third point, and I don't think that we have a sufficient time to start with the third point. Okay, so what will happen, that we will stop here. I hope that I have shown you the correct example. Okay, if you want to know about it more, then you could go to the Google, you could go to the Wikipedia, and you could search about it. And it is highly recommended from my side that you must do it. Why? Because that is just not only for the general knowledge purpose, but also you will be able to grasp the figure in the proper way. It means that you will be able to decode the things. All right. So that's why it's my humble request to you. Kindly go through these disputes. And when you do this, you will get the reference of other things as well. Okay. So that will be a beneficial for you, not just for covering the syllabus, but also understanding the things and finding all the new points so that you could score good marks. All right. So students, basically in this lecture, we have finished till here. In the next lecture, we will continue from here. Till then, just revise all the facts and figures what we have discussed in this lecture and be ready for the another lecture. With this note, let's end this lecture and thank you.